All right. Well, thank you, Myra. Good morning, everybody. It's rare for me to be mic'd up. If you've seen me speak before, you know I like to walk around, and I usually speak very loudly. So if I start doing those things, Myra, give me the signal to cool it. So our topic today is we are now 1 year plus into the Trump administration. This is not intended to be a political discussion at all. Rather, as most of us remember, one of the big issues that Trump campaigned on was reform, including business reforms and employment law reform. So we're here to talk about what changes we've actually seen, as well as what changes are coming down the pike towards us. So specifically, we're going to go over what's been the largest news story of the last year, #MeToo. The only hashtag that strikes fear into the hearts of HR personnel everywhere. We'll talk about what the changes have been to employment laws as well as immigration laws. Some of you may have H-2B visa employees or other operations that immigration laws might impact. We'll go over some proposed legislation that is sitting in Congress right now that would benefit employers. And we'll talk about some changes in administrative enforcement. I would say that if there's been one change that has impacted employers the most under the Trump administration, it has been in how the administrative agencies such as the National Labor Relations Board, the Wage and Hour Division of the Department of Labor are going about administering the laws that they enforce. We'll also have a brief wage and hour update. I know that Myra gave a wage and hour update last month to just about everybody here, but I'll talk to you a little bit about the trend that we're seeing in wage and hour litigation and how to stay one step ahead of the game there. And then, of course, we have to talk about the National Labor Relations Board. Brad was joking with me earlier that he intended to do a shot every time he heard the words protected concerted activity come out of my mouth. If you've seen me speak before, you know that we always touch on this, and it is one of the areas of employment law that is probably the most counterintuitive to HR personnel, so that's why we go over it. And then we'll conclude with a Supreme Court update. We have a few employment law cases before the United States Supreme Court right now that we're waiting for rulings on. There was also a recent case in front of the Florida Supreme Court that may have a pretty significant impact on certain employers that we'll discuss as well. So without further ado, the scary #MeToo, #MeToo and recent sexual harassment cases. Frankly, we probably could have spent the entire morning today discussing the wave of recent sexual harassment cases. You know, let me just briefly give a recap as to how we got to where we are. Really, this movement started with accusers coming out against, you may recall, Hollywood mogul Harvey Weinstein. Since then, countless other CEO types or males in upper management positions have been accused of engaging in various sexual harassment. We've seen people's careers end over this. Harvey Weinstein himself has a number of lawsuits out there against him. Time magazine named the #MeToo movement their Time Persons of the Year last year. They've been featured in Newsweek. As a matter of fact, just within the last couple of weeks, Sports Illustrated had a fairly significant piece on the MeToo movement, which involved sexual harassment at a NBA, National Basketball Association franchise and its inner workings. I'm not going to go over the details of each and every one of those cases, but suffice it to say, the allegations that have been coming forward are far more drastic than your everyday run-of-the-mill sexual harassment lawsuit up until now. There have certainly been one-offs where there have been severe allegations, but the allegations that we're seeing now are truly, in my opinion, doing sexual harassment litigation for the last 16 or 18 years, this is very serious stuff that we're seeing here that's coming out. Why hasn't it come out before? I can't answer that question. I think it's coming out now because the victims of harassment are more willing to tell their side of the story and to make these allegations. Now, from an HR perspective, what does this mean? Well, let's all be mindful, of course, that there is a statute of limitations to bring a true sexual harassment claim, a sexual harassment claim under Title VII or under the Florida Civil Rights Act. The lengthiest limitations period is 365 days to bring a charge with the Florida Commission on Human Relations. But that's not the only type of claim that could be brought against either the company or against the alleged harasser. A very common theory or a common claim that's made is one called negligent supervision that would be made against the company. That claim basically means, or to prove that claim, one has to prove that the company knew of the danger of a particular individual in the work environment, yet they did nothing to stop that individual from continuing to cause harm. So in other words, in plain English, company, you knew you had a harasser on your hands. You didn't do anything to stop the harassment. The harassment continued. You're guilty of negligence. A reasonable employer would have put a stop to this. And then another claim that we've seen, this is actually in one of the Harvey Weinstein lawsuits, is racketeering. You know, you may have heard of a law called RICO, the Racketeering Influenced Corrupt Organization Act, which was designed to go after, frankly, the mafia. But that act is being used against companies in the context of these sexual harassment claims, that they have been covering up the harassment or allowing the harassment to go on. There have also been a few recent cases, and I will say it's unlikely these were connected to the MeToo movement. You know, it takes years to get through the court system, and these are both cases that recently came out on appeal. So these had been in existence for years before the MeToo movement. But they are interesting from an HR perspective. One of those cases involves Costco, the big box retailer. In that particular case, the Equal Employment Opportunity Commission actually sued them after investigating a charge of sexual harassment. What was a little bit different about this particular case was that the victim, the person who filed the charge, was a cashier at Costco, but the harasser was not an employee of Costco. The harasser was a customer who came into the store, and every time he was in the store, he would go through this cashier's line and harass her. She complained about it to Costco. Costco did nothing to ensure that she worked in a harassment-free work environment. You know, they could have, of course, banned the harasser from the store. They could have made sure that he was steered to a different line every time he was in the store. And needless to say, Costco ended up losing that case. The moral of this story, it doesn't matter whether the harasser is a coworker, a supervisor, or a customer. It could be anybody. It could be the FedEx delivery person. You know, if the FedEx delivery person is harassing your receptionist, call FedEx and tell them, you know, put a stop to that. Your duty as the employer is to ensure that your employees are working in a harassment-free environment. The second case that I've listed here, Tequesta versus Luskovich, actually came out of Florida. The Costco case did not, but this one did come out of Florida. And the basic fact pattern in this case is that there was an after-hours party, or a party over the weekend at one coworker's home. And during that party, various egregious acts of sexual harassment took place. And then when the employee returned to the work environment, she was too embarrassed to continue working there. In fact, some of the conduct was undertaken by her direct supervisor. She brought allegations of sexual harassment as well as retaliation, and she ended up prevailing in that case as well. The moral of the story here is it doesn't matter whether the quote-unquote harassment takes place within the workplace. It's whether the effects of the harassment are felt in the workplace. So while most employers, I think, should have the attitude that, hey, we don't care what you do on your own time, we're not here trying to tell you how to live your life, there is a caveat to that. The caveat is, as long as you're not harassing coworkers outside of the workplace and the effects of that harassment spill over here. So to the extent you've ever fielded a complaint about something that has happened off campus, so to speak, and you're inclined to respond, hey, what happens away from work is not my business, be forewarned. That is not the state of the law right now. And I don't see any change in that coming anytime soon. So what are the best practices to minimize the risk of a harassment claim being brought against your company? Well, number one, if you don't have this already, include a complaint procedure in your anti-harassment policy. Assuming, of course, you have an anti-harassment policy in your employee handbook. If I see a lot of heads nodding, and I'm not going to ask you if you don't have one, but if you don't have one, it's time. Make sure you have a complaint procedure. The more robust the complaint procedure, the better. What do I mean by that? I mean have multiple avenues down which somebody can complain. Don't limit the complaint procedure to just one person that an employee can complain to. For example, if the complaint procedure says, go to HR, that's about a C- in my book. Or go to your direct supervisor, C-. I think you should have you can go to HR. If you're not comfortable going to HR, you can go to your own supervisor. If you're not comfortable going to your own supervisor, you can go to the president. You can go to any member of management. If your organization is large enough, I strongly encourage having an 800 number that employees can call. There are vendors out there that provide that service. They will funnel the complaints back to you so that you can address them properly, which leads me to my next recommendation. Take every complaint seriously. Investigate any complaint that you receive and investigate it effectively. What do I mean by investigating effectively? Well, an effective investigation is one that is prompt, that kicks off right away. Some of the most problematic investigations that I have to defend seem perfectly legitimate as to the reasons for their delay, but they're just so difficult to explain 2 years later when you're finally in court. For example, we couldn't begin the investigation because so-and-so key witness was out of town, or the president of company was away on business for 3 days, and we needed to make sure that the president was aware of what was going on. Hey, those sound like legitimate reasons, but in my opinion, those are obstacles we need to overcome. We need to figure out a way to get this investigation off to a start and advise the president if the president needs to be advised, or contact witnesses at home even if they're on vacation. Certainly if they're roped into an investigation, I would pay them as well so we don't run into a wage and hour investigation. Consider their time talking to you to be hours worked, but get things going. The second factor here in conducting an effective investigation is to ensure that there is a level of independence. The HR department may well be independent enough to effectively investigate, but what if the allegation is against the president of the company or the CEO? Can HR truly conduct an effective investigation because HR reports up to the president? I don't know. I think every organization is different, and I think that the company should be aware of the risk that this will not look like an independent investigation depending on the particular circumstances. Do you necessarily need to have an attorney conduct the investigation? You could, and there are advantages to doing so. One of the advantages may be, quite candidly, that the investigation communications, the communication from the attorney back to the company, would be privileged. You may choose at a later time to waive that privilege in order to support your defense should you end up being sued by the victim, the alleged victim there. But the downside is, hey, attorneys, and I'm one of them, are expensive. I completely understand that. But be mindful there might be circumstances where you would want to have one. You may also want to have an HR consultant from outside the organization come in to do an investigation if you feel that you wouldn't be able to conduct an independent investigation on your own. The downside to having the consultant, of course, is that any communications would not be privileged, and that the investigation notes themselves would likely be discoverable if there ever was a lawsuit. And then finally, I recommend effective pre- and post-investigation communications with the complainant. One of the things that I frequently see when I'm defending a harassment claim is the victim saying, I complained, HR interviewed me, and then I never heard anything about it again. It is perfectly okay to tell the individual at the outset, here's what we're going to do. I'm going to gather facts, I'm going to speak with various witnesses, I'm going to circle back with you, to get more information on whatever else I uncover. And then at the end of the investigation, I'll let you know that it has concluded. I'm not going to necessarily tell you what disciplinary actions we take against other employees, but I will at least let you know that we've concluded the investigation and give you the opportunity to share anything else that you want to share at that point. And then, of course, follow through. Let them know once the investigation has come to a conclusion. It may or may not be appropriate to share the results of the investigation with them. I do see many investigations that involve exactly two witnesses. It's a he said, she said, and the employer throws their hands up in frustration and says, I can't reach a conclusion here. I don't see anything wrong with telling the employee that here's the conclusion. You said this, the other side said this, we're not able to draw a conclusion either way. However, we will remind not only this person, but everybody that improper conduct is not tolerated here. So that's essentially the verbal warning that's not disciplinary in nature. The reminder back to either a targeted audience or the organization as a whole as to what type of conduct is okay or not okay. It also might be a good idea, depending on the size of your organization, to take the pulse every now and then, to conduct employee surveys in a general sense, just to see if there are widespread complaints about the work environment that haven't been vocalized to management yet, or conversely, to see if everybody seems to be happy in the environment. And I don't think that a survey should be limited to issues of sexual harassment. I think that these should be broad-based about, what's your opinion of the work environment? Have you had any problems with your supervisor? Things of that nature, perfectly okay. And of course, the number one thing that I recommend is training to minimize the risk for your organization. What type of training? I put this into two brackets here. One would be the supervisory training. Why? Because supervisors are frequently accused of being the harassers themselves, so it's important that they know what conduct is not okay under the law. But number two, supervisors are the eyes and ears of the company. Their knowledge is imputed upon the company. So it's critical that supervisors know what harassment looks like so they can report it to you in HR or at the top of the organization if they see it and not keep that to themselves. One of the worst things that can happen to a company is that they're accused of having supervisors who knew the conduct was going on, yet the company did nothing to put a stop to it. The other type of training that I put out there for your consideration is train your non-supervisory employees themselves. Of course, probably want to strike a balance there so that you're not giving employees a blueprint as to how to sue the company, but that's not really the point of the training. The point of the training is to tell them what type of conduct is not acceptable under the company's policies. And most companies tolerate far less harassment than the law allows. As a lawyer, I see all the time these crazy cases where seemingly outrageous conduct takes place, but the court says, yeah, it was bad, but it's not bad enough to be illegal. Most companies would set the floor somewhere near a zero tolerance level where no harassment is tolerated whatsoever. I can tell you that the legal standard for a hostile work environment under Title VII includes an element that the harassment has to be so severe or pervasive that it alters the terms and conditions of employment. That's a bunch of legalese, but what it basically means is the harassment has to be pretty bad before the court's going to find it to be illegal. Most employers do not adopt that same threshold. Most employers keep it pretty close to zero tolerance. All right, we move on now to employment and immigration laws. What has actually changed out there? It might be easier for me to describe what has not changed out there. When it comes to immigration laws, we have probably heard more saber rattling on this than any actual movement from either side. What hasn't happened? Well, number one, we've heard about DACA to the nth degree, but what has actually happened there? Well, really, nothing at this point. Every now and then you'll see a news headline about a dreamer perhaps being deported or threatened to be deported, but there hasn't been any widespread action on DACA, at least as of this point. We've heard about the wall, right? Has there really been much action on the wall? Not really. There was some funding for it in the most recent spending bill, which was passed late on a Friday, right before the weekend when the news cycle is at its absolute lowest. Coincidence? I'm not going to comment on that. But one of the provisions that was in that spending bill was about $1 billion toward the wall. And I think what Trump was asking for was 20 or 25 billion. So you can see that there's only a fraction of what he was looking for, and certainly not enough to really do anything significantly there. Sanctuary cities. We hear about sanctuary cities all the time. Has anything happened with respect to sanctuary cities? Not really. Sanctuary cities haven't been defunded. That's those three topics, in my opinion, it's a lot of politics in Washington, a lot of talk, not a lot of action. What has changed? Well, this is probably the most significant for employers with respect to immigration law. H-2B visas permit employees, workers from outside the United States to come in, and they're given authorization to work on a temporary or seasonal, non-recurring basis if the employer can show that there are not enough U.S. workers to do those jobs, and that the wages that they're going to pay the H-2B workers are not going to adversely impact the U.S. workers in similarly situated positions there. I don't know if any of you have H-2B workers or not. There is some controversy over H-2B employees, one argument being that they're being used to supplant employees that could do the work, U.S. workers who could do the work. About a year ago or so, there was a lawsuit involving workers at Disney in fairly high positions in technology that were being allegedly supplanted by H-2B workers. That's probably the most recent example here locally in Central Florida. What has changed with respect to H-2B visas? Actually, in that spending bill, the number of authorized H-2B visas for next year just about doubled from 66,000 nationwide up to 129,000 and change going forward in the next year. So that is a fairly significant development, especially if you're an employer that uses or may use H-2B workers in the future. It will actually become somewhat easier for you to obtain that visa. With respect to employment laws, most of the changes that we've seen have been rollbacks of prior executive orders or administrative regulations. There really hasn't been much change, with some exceptions, to the actual laws that are on the books, meaning the substance of the United States Code. Title 29 is, and Title 42 of the U.S. Code contain most of the labor and employment laws under federal law. Those really have not changed much. What has changed has been the executive branch of the government's enforcement of those. One of the more significant rollbacks had to do with what was referred to as the blacklisting executive order that was issued during the Obama administration. Under that executive order, which was titled the Fair Play and Safe Workplaces Order, bidders for federal contracts or for contracts with prime contractors with the federal government were required to do things like disclose labor violations as well as alleged labor violations, which means if your company was falsely accused of not paying in accordance with the Fair Labor Standards Act, or you'd been the recipient of a charge of discrimination or an unfair labor practice filed with the NLRB, you'd have to disclose that in your application or bid for a federal contract or a federal subcontract. You also were required to implement various measures designed to further pay transparency, to show that there was no disparity in what you were paying females versus males, etc. And you were prohibited from entering into arbitration agreements that covered Title VII claims. Most arbitration agreements, if your organization has one, lists Title VII as the very first law that has to be arbitrated if an employee tries to bring a claim, among many, but Title VII is certainly one of them. The Trump administration repealed this executive order, so these requirements are no longer present for anybody who's wanting to do business with the federal government or with a prime contractor to fulfill a federal contract. There was also a case involving the OSHA 300 log rules that came out in about 2012. This was actually judicial action, not executive branch action, but it did come out during the Obama administration. The case was the Volks case, and basically what that case said was that OSHA can not only look back 5 years into your OSHA 300 logs, they can also go back 5 years to cite you for failing to report or record injuries or illnesses. That was fairly drastic. You know, the rule prior to that was that OSHA could only cite an employer back 6 months. So now we see the statute of limitations increasing by a pretty significant factor there. Congress ended up passing a joint disapproval of that rule, which Trump signed into to law last year, doing away with that rule. The current rule now, so everybody knows, and I think everybody here probably has to do those OSHA 300 logs, OSHA can still go in and look back for 5 years, but can only cite you for any violations within the last 6 months. So we're back to where we started. For those that have to file EEO-1 reports, by the way, those were due at the end of last month. Hopefully, if you need to file one, it has gotten in there. But you probably are aware that there had been some noise about a new EEO-1 form that would have been extremely more burdensome for employers to complete and submit. The changes to the old EEO-1 form included things like disclosing the compensation to various classes of or categories of employees. The critics of the new form argued that the information provided on that form really don't tell anybody what it is that we're trying to find out, which is, of course, pay disparity among protected groups, you know, males versus females, or among racial or national origin lines there. Ultimately, under the Trump administration, the EEOC says, no, we're not going to use that after all. It does not appear that it is even on the table to be considered for future EEO-1 reports. We'll stay tuned to see if there's any further development there. What is on the horizon? There is a bill that's pending in Congress right now called the Work Flex in the 21st Century Act, which involves a voluntary undertaking by the employer that has benefits for both the employer and the employee. Let me start out by reminding everybody that there is no requirement under any law that's out there, in Florida anyway, that mandates that you provide some minimum amount of paid time off. Some states have been starting to enact those paid FMLA type laws. Florida doesn't have that yet. No employer is required to provide that as a benefit. Many employers do, though, right? It's kind of, you know, the marketplace dictates that for professional type jobs, you have to offer paid time off in order to be competitive. Even for non-professional jobs, most employers offer some form of paid time off. Well, under this particular plan, to encourage employers to provide paid time off, what the bill proposes is that if you do provide some minimum amount of PTO, and I've got the chart here that shows based on the size of the company, there's a sliding scale as to how much PTO you would, you know, provide to take advantage of this particular law. And it also depends on the length of the employee's service. So if they've got more than 5 years, you'd have to give them, you know, more than what you would give to somebody with fewer than 5 years. And you can include paid holidays, you know, so if you already have you know, President's Day, Columbus Day, whatever holiday it is that you give to your employees, that counts toward the minimum here. If you do this, and you're not required to do this, but if you do this, then the bill would allow employers to implement at least one of these work flex type arrangements here. The most significant of which is the first one that I've listed, the biweekly work program. To remind everybody of what the current state of the law is, for non-exempt employees, meaning employees who are eligible to receive overtime, you must treat every work week independently. So if, you know, at 5 o'clock on Friday at the end of your work week, there's some work emergency and the non-exempt employee has to stay an hour later, you gotta give them the hour of overtime, you know, if that causes them to work more than 40 hours in the work week. You can't strike a deal with the employee to say, hey, listen, come in an hour later next Monday, if Monday is in the next work week. Does it happen all the time? I'm sure it does, but don't tell me about it. No, just kidding. You can't do that. You got to pay them the overtime. You can't even have an arrangement where you say, take an hour and a half of PTO next week. Even though the net result is the same, technically that's still unlawful under the Fair Labor Standards Act. You've got to pay the overtime for that work week in which it's worked. Under this bill, the WorkFlex in the 21st Century Act, you would be permitted to implement a bi-weekly work program that says you work 80 hours a week, bi-weekly. Every 2 weeks, we expect you to work 80 hours. You would be permitted to have the employee work up to 60 hours in either of those weeks without having to pay overtime. However, if the employee works more than 80 in the bi-weekly period, you've got to pay overtime for the hours beyond 80. So in other words, this would accomplish what many employers, and frankly, some employees want to do, which is, hey, if I work more now, I'm going to work less later, and the net result is, zero. I get straight time for all the hours. So you could have up to 60 one week and 20 the next, or vice versa, and not have to pay any overtime. Overtime would be more than 60 hours for a single week or more than 80 bi-weekly. This, in my opinion, would probably be the most significant change to the Fair Labor Standards Act that we could reasonably expect within the next several years. Currently, the bill's pending in Congress. It seems to have support, and I would guess that if it were to go to Trump's desk, he would sign that into law. While we are on the topic of wage and hour law, let me share with you what is going on out there in the world of litigation. Wage and hour law, Fair Labor Standards Act, is an extremely popular claim that employees bring. Basically, the claim is this: either I was working off the clock so I didn't get paid overtime that I worked, or I worked off the clock so much that when you look at what my wages paid actually were when compared to the hours I worked, it wasn't even minimum wage. Or another popular theory is that, I'm being paid a salary, I'm not getting overtime, but I'm not actually performing exempt work. Most of us here likely know that paying a salary isn't enough. The employee has to be doing what they call the white-collar work, either professional, executive, or administrative work, or they might work in a computer-related job, or they might be an outside salesperson. There are a number of exemptions, but the key to just about all those exemptions is not how you're paid. That might be one element, but it's what you do, what your actual job duties are. So up until recently, those were the main types of Fair Labor Standards Act claims that we saw. What was particularly pesky about Fair Labor Standards Act claims is that it was very easy for an employee to bring those claims not only on the employee's own behalf, but as a collective action, meaning on behalf of all employees who were subjected to the same pay practice. So all employees who worked off the clock, all employees who were misclassified as exempt. Well, we're still seeing many actions being brought as collective actions, but what is the theory that we're starting to see? Challenges to the employer's time rounding policies. Many employers round time to the nearest 5 minutes, 10 minutes, tenth of an hour, whatever it is, even 15 minutes an hour. Is there anything illegal about doing that? Is there anything illegal with having a time rounding policy? The answer is no. As a matter of fact, the regulations on the Fair Labor Standards Act expressly permit employers to do this, so long as in the long run, the employees are not working more than what they're being paid for. In other words, this setup has to be neutral such that the employee is advantaged by it as much as the employee is disadvantaged by it. And in my experience, the Department of Labor, maybe surprisingly, is fairly pro-employer when it comes to time clock rounding practices. They will look to make sure, of course, if they're doing an audit, that in fact employees are sometimes being credited with more time than what's being taken away as a result of the time rounding practice. But I've rarely seen the Department of Labor get hung up during an audit on a time rounding practice. And I've heard of employers that have some pretty drastic rounding policies. To the nearest 15th minute, that's an entire quarter hour. In my mind, that might be a little risky, but hey, the department is okay with that as long as you can show that the practice is neutral. So what's the basis for these claims that we're seeing that are being brought in private lawsuits and as collective actions? It's that the time and pay records show that the plaintiffs, as well as the others similarly situated to them, are regularly being disadvantaged, that they, in the long run, are being paid for fewer hours that they actually work, and that the employer benefits from this practice. The arguments that the employees are making include comparing the time records to the employer's own attendance policies. You know, most employers that have a handbook probably have a line in there somewhere saying you're expected to be at work on time, and if you're not on time, you're considered tardy, and if you have 2 or 3 or 5 tardies or whatever, that counts as an absence, and if you have 3 absences, we fire you, or something along those lines. Well, the employees argue, you know, we're charged with getting here on time. We have to be here, and if there's 20 of us at a time clock at a time, we can't all be in there right on the minute that we're expected to work. Of course we have to get here early sometimes. Yet it's being rounded back down to the employer's advantage in the long run. So in the short term, maybe the employee is only losing a few minutes a day. But if an employee loses 5 minutes a day, 10 minutes a day, you know, by the end of the week, that's close to half an hour or an hour. Over the course of a year, that could be 25 to 50 hours. If you have 100 employees, multiply 25 or 50 by 100, and now we're starting to look at some pretty big numbers for the potential liability there. So the counter arguments to that would be to show that the time rounding practices are in fact advantaging the employee as frequently as they disadvantage the employee, or disadvantage the employee. Another thing that you might consider doing is, instead of rounding to the nearest top of the hour or the 15 minutes or using the clock as the starting point, count their start time as the starting point. So if they clock in at 7:58, you know, then when they clock out at 4:59, round back to the 58, you know, rather than the other way, in order to show that, hey, we're paying people very close to the amount of hours that they actually work. What can you do to reduce the risk of this type of litigation? Well, conduct a self-audit. You know, I've shared with you what it is to look for, and frankly, I think most employers prior to this wave of litigation weren't entirely sure what it was to look for because they weren't even aware that this could be a concern. Go back to your time records if you have a time rounding practice and just take a look, not just at one work week, but look at a few different employees over the course of several months to see if in the long run they have been paid for fewer hours than they've actually worked. It might be time consuming, but it's not that difficult to do. So I strongly recommend just staying one step ahead of the collective action game that's out there these days. A few other developments from the world of wage and hour under the Trump administration. We've heard rumblings that the Department of Labor will issue opinion letters again. The department stopped doing this under the Obama administration. In my opinion, opinion letters are a fantastic tool for employers because if you genuinely have a question as to whether your practice violates the wage and hour laws, you used to be able to write a letter to the department, and I've written several of these, saying, here's what the practice is. We think that this is okay. Here's why we think it's okay, but we'd like your opinion on this. And when I've done it, I've been able to do it anonymously. You know, I say, I have a client that is asking the following question. So you're not identified, you're not red flagged for an audit, you know, coincidentally down the road. And you would get a letter back from the Department of Labor that says either yes, you're okay, or no, you're not okay. If you have that type of letter and you rely upon it, you can avoid certain liabilities if an employee later sues you for that very same practice and ends up winning in court because the judge disagrees with the Department of Labor. So these were very good tools, but they stopped in, I think it was 2011. It might have even been earlier than that, but there's some rumblings that those might be back on the table. Also, if you've ever had the misfortune of being part of a Department of Labor audit, you may know that the Department of Labor has been recently seeking liquidated damages on top of any back payments the department feels are owed to employees. Liquidated damages in this context means an amount of money equal to whatever the back payment is, whatever the employee should have been paid in the first place. Department is discussing dropping that as a mandatory penalty now. Additionally, if you've been audited multiple times and the department finds a violation on multiple visits out there, even if it's a different violation, the department will assess a civil money penalty against the employer. The civil money penalty is about $1,100. It actually just went up a year or two ago. It's now an odd number, like $1,187, I think, per violation. Well, what does per violation mean? The department has great latitude to determine what per violation means. It could mean one violation for every employee who's affected. So you have 25 employees who are affected, multiply that by $1,187. It could mean there's a violation in every work week in which the employee is not paid properly. Take your 25 employees and multiply that by every work week in the normal 2-year limitations period. The department is reassessing when to assess those civil money penalties. And specifically what they're assessing is whether to continue issuing this penalty when the violation they find the second time around is something completely different from what they found the first time around. Because, think about this, it is somewhat unfair to the employer when they cleaned up the violation the first time, they changed their practice, and then for whatever reason, there's a completely different violation the second time around, either that wasn't in existence before or that the department, for whatever reason, didn't catch before. And given the amount of the penalties and how significant they are, this is a pretty big change for the employers. The department's also revisiting exactly what information they're going to ask for when they come knocking on your door. Hopefully nobody here has ever had that knock on the door, but if you have, you know that the investigator from the Department of Labor shows up, flashes the badge, drops a letter on the desk saying, we'd like to look at all these documents, and then says, can I start interviewing people right now? Your response, by the way, should be, hold on 1 minute. You can give me a call, give Myra a call. There's a Department of Labor investigator here, what do we do? And normally if you say, listen, you kind of caught us by surprise, we're happy to have you come on back within the next week, but let us figure out a time for you to do that, and they're normally okay with doing that. But they won't stop on their own. You do have to ask them. The final wage and hour update I want to give here is that there actually was an amendment to the Fair Labor Standards Act in the new spending bill. It pertains only to tipped employees. I'm not sure that anybody here has tipped employees, so I'm not going to go into this in a great deal of detail. If you do have tipped employees, see me afterwards and I'll give you the scoop on it. But basically the amendment says that if you have tipped employees, the employer cannot keep any part of those tips, including but not limited to sharing those tips with managers or supervisors. Frankly, that's already the law, but it wasn't in the FLSA itself. It was in the regulations. It's now there. All right, everybody's favorite time of this presentation, the NLRB update and protected concerted activities. Got to take a shot. It's just water, I promise. For those who don't know what I'm talking about, when I say protected concerted activities, I will give you the 30-second tutorial. The tutorial is this. Section 7 of the National Labor Relations Act gives employees the absolute right to engage in concerted activities for the employee's mutual aid or protection. What this means is that if you have 2 employees or more and they are talking about terms and conditions of the workplace amongst themselves, that generally is absolutely protected conduct. Where do employers stumble upon this or stumble when it comes to this rule? Well, by having handbook policies such as don't discuss your compensation with each other. That's confidential. You can't have that. That is the textbook example that the NLRB actually uses to show what types of policies violate this rule. Up until very recently, December of 2017, the standard for deciding whether your handbook policy was unlawful and in violation of Section 7 was that if an employee could reasonably construe your policy to prohibit conduct that's protected under Section 7, protected concerted activities, then the rule was illegal. The NLRB used that legal standard to find a plethora of policies to be unlawful. Policies that even I would not have predicted could have even come close to being construed as violating Section 7. Those policies included things like, prohibitions on using your camera phone in the workplace. Illegal. Why? Because, the NLRB reasoned, well, an employee might want to take out their camera phone to snap photos of an unsafe work environment and then share those photos with other coworkers or even with the media, all of which would be protected concerted activities. So you can see that the tentacles of Section 7 go far. And as a result, when I'm doing a handbook review, I'm not merely looking to make sure that your FMLA policy says what the law says. I'm looking to see if you have policies that the NLRB would find unlawful because, heaven forbid, if an employee files an unfair labor practice charge against your company with the National Labor Relations Board, the first thing the NLRB will ask for is a copy of your handbook so they can go through it line by line and decide what's illegal. So you're starting off your investigation on the wrong foot already if you have any unlawful policies in there. Well, lo and behold, under the Trump administration, which did see a shakeup in the board's makeup, the NLRB, by the way, made up of 5 members, 3 of which are traditionally from the president's party, 2 of which are from the opposing party. So under President Obama, it was 3 Democrats, 2 Republicans. When there were actually 5, and many times there were only 3, and in some instances only 2, because the Senate would never confirm any of the board members. We actually have 5 now. We have 3 Republicans. We have 2 Democrats. What does that mean? In all likelihood, we're going to start seeing some of the board's previous policies reversed. In fact, in this particular case, the Boeing company case, what was involved there was a policy prohibiting the use of cameras in the workplace. Previously, the board said this is unlawful. This violates Section 7. It could reasonably construed to violate Section 7. The Boeing board reversed that. But I can't say that the reversal applies to everybody. On this specific rule, the camera phone rule, it applies to Boeing because Boeing, as you might imagine, has various top secret documents and information in the workplace, and we don't want, corporate espionage, especially when Boeing is a contractor for the Department of Defense and the federal government, et cetera, et cetera. And to arrive at that conclusion, the board said, we're no longer going to use this standard under which if an employee could reasonably construe the rule to infringe on their Section 7 rights, it'll be unlawful. Now what we're going to look at is a few things. Number 1 would be the nature and the extent of the potential impact on the NLRA rights, your National Labor Relations Act rights, your Section 7 rights. The camera phone is so far removed from your traditional Section 7 type activities that this factor weighed against the NLRA or NLRB's position. And are there legitimate justifications associated with the rule? Well, if you're Boeing, you've got good reason to not want to have camera phones in the workplace. So given those 2 factors, the rule was struck down. Interestingly enough, and of most importance, I think, going forward in evaluating your own handbook policies, the board in this particular case said from henceforth, we're going to look at these rules as falling within one of 3 categories. The rule either is going to be what they call a Category 1, which frankly I do not like, given that we live in Florida, and categories 1, 2, 3, 4, and 5 are usually associated with bad meteorological events. Nonetheless, Category 1 under the NLRB's new rule will include rules that the board designates as lawful to maintain, either because the rule, when reasonably interpreted, does not prohibit or interfere with the exercise of Section 7 rights, or the potential adverse action is outweighed by legitimate justifications. Example would be Boeing's no-camera rule. Not necessarily your own no-camera rule if you're significantly different from Boeing, but Boeing's rule fell in there. Also, rules requiring employees to abide by basic standards of civility. I cannot tell you how many hairs have been split on code of conduct policies over whether insubordination or gross insubordination or refusing to perform a work rule would be okay, as opposed to you need to treat your coworkers with respect. Traditionally, that's not okay, although under the new board ruling, it might well be now. Moving on, Category 2 would be rules that require an individualized assessment to determine whether or not Section 7 rights are violated. And if so, would that be outweighed by legitimate justifications? We frankly don't have a good idea as to exactly what Category 2 rules might be. In my opinion, if it's a rule that the lawfulness was changed under the previous administration, it's probably going to fall within Category 2. I suspect the Trump administration is looking for reasons to overturn board rulings that came out under the Obama administration, which might include things like the confidentiality of your internal investigations. You know, there was a ruling by the board a few years back that said you cannot tell employees that they have to keep their contents of the investigation to themselves and maintain confidentiality unless you can show that there's some specified need, some specific need to do so, like an imminent threat of retaliation or something along those lines. That rule is probably going to be changed. Using company email after hours to engage in union activities, permitted under the Obama board, probably, I would guess, would be one that might be revisited. But the moral of this story is proceed with caution for the time being on those types of rules. If there's still an outstanding board decision that's still good law that says this is an unlawful policy, I would wait until the board actually reverses it to do that. And then your Category 3 rules would be the rules like don't discuss wages with your coworkers. I mean, that's clearly a violation of Section 7, and there's really not any argument to get around that. So other topics that are likely would have to do with things like joint employer status. You know, there were some significant rulings under the previous administration's board where an employer could be found liable even with minimal ability to control the terms and conditions of another employer's employee. You know, the McDonald's franchise was probably the most famous case where corporate McDonald's was held to be the employer as well as the little franchise McDonald's. And corporate McDonald's was like, well, wait a minute, we don't know what they're doing down there in whatever small town to run their store. Why should we be held liable? Well, currently they would be liable, but perhaps we'll see a change there. So let me wrap up by giving you the Supreme Court update. We do have a few cases that are in front of the Supreme Court. Just so you know what the Supreme Court's cycle is, you know, they are not a court that is open 365 days a year. Their term runs from October through about June. From October until, February, March-ish, they really don't do much except for hear oral arguments on the cases in front of them. And then from February, March-ish up until June, they start releasing their opinions on the cases that are pending in front of them. Some of the more famous cases and the ones applicable to workplace law have to do with whether arbitration agreements are even legal, because most arbitration agreements have a class action waiver component to them saying, hey, so-and-so employee, if you bring a claim against us, number one, you agree to arbitrate it rather than go to court. And number two, you agree that your claim is going to be heard on an individual basis and you're not going to be able to bring a class action. Well, the argument as to why this might be illegal is, again, protected, concerted activities where the board takes the position that employees have a right to bring class actions, and that's a form of the protected, concerted activities under Title VII. We will see how that case comes out. I'm going to predict that the court's going to side in favor of allowing those arbitration agreements simply because the Federal Arbitration Act seems to expressly provide for arbitration. And given the makeup of the current court, I just have no reason to think they'll go the other way. The second case, though, I am far less sure as to what the result will be. And this, of course, is the wedding cake case, right? It has to do with the balancing of religious beliefs of the employer versus the anti-discrimination laws that prohibit discrimination on, among other things, sexual orientation or gender identity. The wedding cake case, just to briefly remind everybody, a baker out in Colorado refused to bake the wedding cake for a same-sex couple. They got sued. The bakery lost, I believe, at every level in front of the state commission and all the way up through the courts. And they're currently before the Supremes to see what they do. The reason I really have no idea as to how this one is going to turn out is that the court traditionally has a majority of 5 relatively conservative justices, ranging from extremely conservative to kind of middle of the road, and then 4 that you can always count on to go the other way. They're the liberal minority, where it's rare that any of those 4 break from each other. But within that 5 majority, there's one justice, Justice Kennedy, who historically has always sided with LGBT rights. So it will be interesting to see how this one comes out. I'm sure it will be a 5-4 split. We just don't know who will be the 5 and who will be the 4. The last case that I'm going to update you on has to do with non-compete agreements. I don't know if you use non-compete agreements as an employer or not, but a recent case in front of the Florida Supreme Court is frankly going to make it much easier for employers to enforce non-compete agreements. In this particular case, it involved a home health provider, you know, the type of group that sends a physical therapist or an occupational therapist out to somebody's home, you know, once a week for an hour or however long. Well, the way those companies get their business is from referrals from doctors. You know, they're not doctors themselves. They don't have their own patients. The only way they get work is, frankly, by having a sales team that goes out and makes relationships with the physicians, and the physicians say, we need an occupational therapist, and patient, I recommend you go to, you know, AAG or Hammond's physical therapy, occupational therapy. And that's how those companies get their business. Most of those companies have non-compete agreements that their sales personnel sign saying, I'm not going to jump ship and start competing against you. In order to enforce a non-compete agreement, an employer has to show that it has a legitimate business interest in enforcing that non-compete. The statute in Florida that lays out the law, which is 542.335, if anybody wants to look it up, and if you have insomnia, I strongly encourage it. That statute lists a number of specific legitimate business interests, and among them is listed existing clients or specific prospective clients or patients, etc. The theory that most of these home health providers would use when they would sue for violations of a non-compete is, hey, you've jumped ship over to a competitor and now you're going after our referral sources. You might not be taking our actual patients away from us, but you're taking our potential patients away from us as well. This issue's already been addressed by the courts. You can't argue that some vague nebula of prospective customers is being taken away. You've got to point to specific ones, like John Smith was going to come with me next week, and you took John Smith away. So then the home health companies started arguing, well, referral sources are a legitimate business interest that we have the right to protect. And there was a split in the courts. Some courts said yes, the statute, even though it doesn't list referral sources, the spirit of the statute would include those. Other courts said no, we're only going to find that the specific items listed in the statute are protectable business interests. Finally, the Supreme Court, Florida Supreme Court, decided the issue, and it came down on the side of referral sources, even though they're not listed in the statute, are a legitimate business interest. This is how you get your business, home health industry. Therefore, it's perfectly legitimate for you to seek to enforce a non-compete. How does this translate to you if you are not in the home health industry? Well, the answer is it's become easier now to enforce your non-compete because now you don't have to point to one of the specific items listed in the statute, the specific customers, the specific prospective customers. Now you almost have carte blanche to come up with whatever compelling business interest that you have and to try to convince the courts that this is compelling enough to enforce a non-compete. Whereas previously it would be very difficult to do so, now the Supreme Court seems to have opened the door for that. So if you use non-competes, you know, be mindful that they're probably easier to enforce. If you're subject to a non-compete, be mindful that they're probably now much easier to enforce as well. With that being said, and with another speaker coming up, does anybody have any questions about what we've covered so far? Thank you all very much.
Good morning, everybody. How's everybody doing this morning? Good, good. My name's Chad Geyer. I'm from ABA Insurance Services. Mike Reed, one of our managers, is here also today to talk to you guys a little bit about cyber liability risk. ABA is a professional liability company. One of the areas we specialize in is cyber liability insurance, and we've been in that area since 2001, so we have a lot of knowledge on the subject. So what we came to talk to you today, kind of keep it at a high level. We're going to talk to you guys a little bit about what is a cyber attack, how is my business exposed to a cyber attack, and what are some of the steps that I can take to prevent a cyber attack. So we're going to start off with a little exercise. As I ask a question, if the answer is yes to that question for your business, just go ahead and raise your hand. But does your business take credit card payments? Okay. Does your business do any online banking? Does your business use any type of social media, so Facebook, LinkedIn? Okay. Does your business store any sensitive customer or employee data? Okay. So does your business use the internet? That's everybody, right? So the reality of that, the reason we ask these questions is because the reality of that is that your business has a cyber risk. A lot of people think of cyber insurance and cyber risk as just gaining customer information. We see the big hacks on TV like Target and Facebook and everything, but it's a lot more complex than that. And there's a lot of other areas that you're exposed to an attack. We're going to focus on 3 of those today that are the big ones for you. But just to kind of give you guys an idea of some numbers, 62% of small to mid-sized businesses make up most of the cyber attacks that happen in the claims that we see. And the reason for that is because most of these businesses don't have the infrastructure in place to prevent a cyber attack. So in essence, these small to mid-sized businesses, a lot of them are kind of an easy target for cyber criminals. So it's much more complex, and doesn't just happen to Target, doesn't just happen to these large corporations. It happens even more so to your small to medium-sized businesses. Some of the, oops, skipped one here. Where'd you go? Okay, that's out. So there's supposed to be a chart here. It looks like the page came up blank, but so we're going to talk today about three different areas that small businesses are generally most exposed to. That'd be fraudulent funds transfer, social engineering, which is somewhat of a byproduct of fraudulent funds transfer, and then we're also going to talk about ransomware. So to dive in first, we'll get into fraudulent funds transfer. And what is fraudulent funds transfer? So it's basically the loss of money to an unauthorized user, instructing your bank to wire money from your account. So how does this happen? Generally, most of these attacks happen through email. So a cyber criminal will send email that looks like it's something you should open. For instance, say, your FedEx shipping package has arrived. I didn't order a package. What's this about? You click on that. Boom, now you have malware or virus downloaded onto your computer. That's how they get in. And once they get in, they obtain information for fraudulent funds transfer. They're obtaining information that they can then basically just direct your bank to send money to their account out of their bank account. An example of this would be we had a claim. We had a business, a small business that the CEO was reconciling some accounts. He saw 3 unauthorized transactions that totaled over $200,000 in his account. So he called the bank, had the account shut down, but unfortunately, the bank wasn't able to recover that money. So and later on, it was determined that how the cyber criminal got in there was that he got the malware downloaded onto the company's computers, found the CEO's username and password for the bank account, and was directing them to take money, the bank to send money into a different account, and it looked like it was coming from the CEO. So to give you an idea what fraudulent funds transfer is, kind of give you an example of what that is fraudulent funds transfer. And then we move into somewhat of an offshoot of that. This is somewhat of a new trend within cyber insurance. It's called social engineering. And that's more trickery or scamming an employee into revealing either sensitive information or sending unauthorized funds or information to a third-party account, to a cyber criminal's account. So once again, happens through via email. They will send an email that looks very official. Let's just say, for example, you use Verizon for your internet and for your phone service. They can make a very official-looking email that says, "Hey, this is Verizon. we've changed your deposit account to this new account. Please change your deposit information to this account and start making your payments to this new account. So that's kind of an example of how social engineering, how it's a little bit different from fraudulent funds transfer because it's actually scamming an employee into giving up information and giving up money. One example that an agent shared with me that I thought was pretty relevant, and it really ties in the social piece of this, because when we talk about social, it's more social media, social engineering. We had a situation where they insured a company, and the CEO traveled to Japan quite a bit for business, and he also was a car aficionado. So loved automobiles, and someone clicked on an email, and some malware was downloaded onto the company's infrastructure, into their website or into their company computers. The cyber criminal learned, okay, this guy travels to, this is the CEO, this is the accountant, this is the CFO. Kind of learns who's who in the business. Also learns that the CEO travels to Japan a lot, but also what that cyber criminal was doing was checking in on Facebook on these different people in the company, and through Facebook, he found that the CEO was a car aficionado. So he was able to figure out and time it up to where one of the times the CEO was on his trip to Japan, and he sent the company accountant an email saying, hey, I found this car I really love here in Japan. Wire me $150,000 to this account I set up so that I can buy this car and ship it back to the United States. Boom, just like that, $150,000 is gone. So that's kind of an example of social engineering. It's the more new popular one. These generally happen on a much smaller scale. You guys probably see it every day in your business where you'll get an email from somebody that says, hey, like I said, this is FedEx, you didn't pick up a package, or this is a CEO, hey, send me some money, send me some money to this account so I can pay this bill or whatever it may be. These are things that you guys probably have seen at some point in time in your business via email. So ransomware. So this is one that probably you guys hear a lot more, and may have heard from other businesses that they've experienced. This is where a cyber criminal gains access to your system and either locks down key files you may need, or they just lock up your system in general so that you can't do any business. So this is very common. Generally, they ask for a very small amount of money, and they want to be paid in cryptocurrency. So to kind of give you an idea of how that affects your business and how that can really hurt your business and your production is. Yeah, I'll pick on you if you don't mind. What type of business are you in? Okay, so let's just say I'm a cyber criminal. I somehow get into your system. I lock up. Let's just say a bunch of your key customer files. But I'm not such a bad criminal, so I'm going to say, hey, I'm an okay guy. For $2,000, I'll unlock that for you. But I need you to pay me in Bitcoin. So now stand up and tell everybody in this room how to get some Bitcoin. Can't do that? Yeah, neither can I, so don't feel bad. So that's the reality, and that's where it really hurts you, is that it takes time to figure, okay, well, 95% of us in this room probably don't know how to get a hold of that type of money to pay off this criminal. That takes a lot of time, and it can shut down your business for several days. It can even go to weeks. And at that point, you're losing a lot of money because you can't do business. So these are kind of the three big things that you're going to experience. Like I said, these make up half the claims from cyber, as far as we see from our cyber insurance. And these are going to be the big, what we like to call the big three that you're most likely to experience. So most of the time, if you have a business owner policy in place and you have an endorsement for cyber, they are not covering most of those endorsements on your cyber or on your business policy do not cover funds transfer, social engineering, or ransomware. They're really just covering data breach, where you go in and steal customer information. So a lot of small businesses, they think that, well, I don't retain customer information. Some of us don't even really retain that, or keep on file that much employee information, so I don't have an exposure. But the reality is you do. So your account can be hacked, your system can be locked up, and you can be kept out from doing business. Someone in the organization, it's just human error, can be tricked into sending money to somebody they shouldn't be sending money to. These are all very real things that happen on a daily basis in the world of small business. So these are things that you guys definitely have an exposure to. And that's what we try to educate people on, and make sure that you understand that it's not just about stealing customer information. It's much more than that. So we're going to bring up Mike to talk a little bit. He's going to kind of go through some of the costs that can be associated with some of these claims. Once again, how it can affect your business. Then he's going to wrap up with a few things, just to kind of here's a few things that you guys. So we're going to talk to you guys a little bit about some things that you can do to help prevent these type of attacks, and then we'll leave some time for questions for you guys also.
Good morning, everyone. Thanks, Chad. That was great. The reality today is that you can't pick up the Wall Street Journal or turn on the news or read the newspaper without hearing about a cyber breach. And I guess that's good and bad, right? It's good because there's more awareness of cyber and what that actually means, but it's bad because these things are happening. And Chad gave 3 examples, and the things that he mentioned, those 3, funds transfer and social engineering and ransomware, make up half of the cyber claims out there. So when you hear the word cyber, it's kind of nebulous and it means different things to different people, right? But really, when we talk about cyber, we're talking about those 3 things. I want to talk to you a little bit about the expenses that your business can face if you have an actual or suspected cyber breach. And that's really important, right? Because the reasonableness standard in most states is that if you have something that you think could have exposed customer information or exposed other sensitive data, you are obligated as a business to investigate that. And when you do so, you incur significant expenses, whether there was an actual incident or not. So in the insurance world, we break these costs into what we call first party and third party. And simply put, in English, what that means is first party are those expenses that your business incurs to investigate and respond to an actual or suspected incident. You have breach evaluation costs, right? If you have an event, you need to know what happened, how it occurred in the first place, and what steps you need to take to stop that immediately. Those IT forensic costs. On average, across our book of business, we write several thousand cyber policies. The average cost that a small business incurs is $26,000 just for that part alone. The legal review is also extremely important. There are a number of state and federal laws that businesses have to comply with when an actual or suspected breach occurs. The average cost legally to figure out what you need to do next, your next steps, is almost $50,000. Then there's the short-term crisis management, right? Business interruption costs that you may face because your systems are unavailable or your files have been locked because of ransomware. There's public relations and crisis management expenses. So think about if you're in a business that's in a fiduciary or even an implied fiduciary capacity, right? You're a bank or an accountant or a brokerage house, an investment advisor. You're handling people's money, right? Imagine if word got out that your systems were somehow compromised. That can be incredibly damaging and would be incredibly damaging to your business. So those expenses, those what we call crisis management expenses, again, nearly $30,000 on average. Then of course, if there was an actual breach, if confidential information of your customers, we call PII, personally identifiable information. If that's been compromised, then there are a number of steps and laws that you need to follow to notify those folks that their information has been exposed. The costs of doing that, $16,000, right? That's preparing letters, sending letters. That's typically a call center if you've had more than typically 25 or so records exposed. These are real dollars and they add up very quickly, and you can see how fast, for example, these may add up and eclipse the cost of a fire at your business or damage from a storm, right? These we're talking about big time expenses that for small businesses can be catastrophic. And those are just the expenses that you incur. The third party costs are those judgments or settlements or regulatory fines that might be levied against your business. Class action lawsuits are incredibly expensive. They're really scary and they cost a lot of money. Regulatory fines and penalties, particularly if you were found not to be compliant with credit card standards, average nearly $70,000. And then of course you have the reputational damage and the long-term income loss to your business. And I'll go back to, if you're in a fiduciary or an implied fiduciary business, your reputation is everything to you. And if that reputation is to be harmed because of an event, that can put you out of business, right? And the costs of that are astronomical, nearly $250,000 from what we've been able to calculate. So these are real dollars that affect small businesses like all of ours, including ours. We have 65 employees. We face the same sort of threat. So from a risk management perspective, what can you do to manage cyber claims? Well, folks, with everything, the key is education, right? Educating yourself and your employees about what's out there and about what can happen. There are a number of resources publicly available, really good resources. I would imagine your local Chamber of Commerce has information. There's seminars like you're attending today. I would encourage you to get out there and read those articles, watch those news stories, and talk to your employees about those as well, because that's really the key to stopping it. Chad mentioned with the fraudulent funds transfer, how typically those begin with bogus emails, right? FedEx, your package has shipped, click here to track it. Or we get ones, I get emails every now and then, particularly this time of year, from the IRS. You may be under audit, you need to click here to advance that. I get emails from the Better Business Bureau. I get one about every other week from Delta Airlines. I haven't been on Delta in probably 20 years, but I get an email from Delta. Log in here, click here to log in to check into your flight. Okay, those are all bogus and they look very legitimate. So you click on those, next thing you know, you've downloaded a virus or malware or key logging software into your system, and you could be in big trouble, right? So the key here, I think, is educating yourselves and your employees about what's out there. For those businesses that have the wherewithal to do this, it's really important that you have a cybersecurity policy as part of your standard operating procedures, right? Employee handbook, your company guidelines. You want folks to know what they can and can't do with their machines, what they can and can't do with portable flash drives and thumb drives. We had a claim at a bank that we insure where an employee found a thumb drive in the parking lot and plugged it into their computer to see what was on it. And it infected their organization with malware. Things like that, right? It seemed like, why in the world would you do that? That actually happens, and so it's important that you have that written into your policies and procedures so that your folks know that they cannot do that sort of thing. The other thing, it's so basic, right? But you want to keep your systems up to date, your hardware and your software with the latest antivirus and anti-malware systems. Oftentimes companies are good at doing that. We're good at doing that, but Microsoft every now and then will detect and notice vulnerabilities and issue patches out there, right, that you need to go and download into your system. I'm not very good at doing that. I imagine most of you aren't either, because those tend to fly under the radar. That's something that you want to be cognizant of as well. Then the last thing you want to do is, as a backstop, you want to have, and it's important to have, a good cyber insurance policy in place, right? So that's your backstop. In the event you have a claim, you want that policy there standing behind it. A lot of cyber coverage that's available in the market today is, most of you have what's called a business owner's policy, a BOP, business owner's policy, that has a little bit of cyber. We call it a bolt-on, an endorsement to that policy. That's not good enough in today's day and age, because that's typically limited coverage, lower limits, and it doesn't cover the full breadth of exposure out there. Those typically, for example, don't respond to the social engineering claims that you heard Chad about. So I would recommend that you work with a good insurance agent that can really help you place cyber cover from an organization that has experience with it and knows what claims look like and knows how to handle those. Okay. We left some time for questions and we're happy to take those. I guess I'll ask the first question, and because this is something we typically hear from business owners. And the question is something like, or the concern is something like, well, I don't keep any confidential customer information in-house, right? I've got some of that, but I typically upload those files to the cloud. I use Dropbox, or I use the Microsoft cloud service, or I use Google Docs. I don't have anything in-house, right? I don't have an exposure. Well, the reality is that if you have a customer, or if you have someone whose confidential information was exposed, they don't care if you upload that to the cloud or use that kind of service. All they know is they had a business relationship with you and their information was exposed. So they're going to come after you, right? Now, that doesn't happen all that often, but what does happen is you may have employee information on file, right? So you have employees' social security numbers, or you have an employee's bank account information because you deposit their pay into their account via ACH every couple of weeks. You have confidential information that you're holding, typically whether you recognize it or not. So the objection that I offload that to the cloud doesn't really work, right? You need cyber insurance even if you do that sort of thing. Other questions in general that Chad and I can help you with, or things that you want to talk about regarding cyber? If there are, Chad and I, or if any come up, Chad and I will both be here afterward, and we're happy to chat individually if you would like. And thank you for your time this morning. Appreciate it. And thank you, Myra, for the opportunity to be here.